I'm going to be speaking about the legal work package, and I would like to start, given that acknowledgement of my place at UCL when the project commenced, by noting my research associate Chiara Mani, who's in the back row there. And you've already seen this slide several times today, and I just wanted to re-emphasize that the acceptability of geoengineering, as the Royal Society report underscored in 2009, will be determined inter alia by social issues as much as by technical factors. And the recommendation, one of them in the report, was to develop the implementation of governance frameworks for both research and deployment. Now, in the conclusions, the Royal Society report also referred to the fact that some methods could already be effectively governed or managed by amending existing international law or under national regulations, but that there may be gaps in the legal framework requiring new mechanisms. And it recommended a review of the role of existing treaty bodies, identifying existing mechanisms that could be used to regulate geoengineering research and deployment activities, and identifying regulatory gaps. And that, of course, is where Work Package 3 on law and regulation came in. We wanted to take forward some of those conclusions and the recommendations and to examine the extent to which, in the context of legal regulation of geoengineering, there are limits to control it under different circumstances, how many existing geoengineering technologies or future imaginaries are addressed under, or could be addressed under existing laws, regulations, and treaties, what new provisions might be necessary, and so on. If you will, this was examining the black box assumption of the Royal Society report that national laws and regulations are in place and will be largely effective for the regulation of encapsulated technologies, and that the action was really going to be at the supranational level because of transborder implications, because of regulatory gaps in respect of the atmosphere, and because of the need for international regulation. So our work package looked at two fundamental features in terms of methodology. One was to conduct an assessment of the current international regulatory framework, the existing mechanisms, and we developed an set of assessment criteria for that, which I'll come on to in a moment. But we also wanted to drill down into national jurisdictions, and we chose the UK, Germany, and the United States. So geographically, looking at those three national jurisdictions. Why? Because these were jurisdictions in which there had already been some national debate and emerging academic discourse, although, as I'll come on to point out in a moment, in none of these contexts do we find geoengineering-specific regulation. In those national case studies, we didn't want to work with a blank canvas, so we chose three what I would call case studies or contexts for an evaluation of selected US state law, German law, and UK law. And in the UK, we did look at the different jurisdictions, so a little bit of Scots law in there as well. And essentially, these were three different contexts. One was encapsulated carbon dioxide removal techniques. The second was the unencapsulated, of which ocean iron fertilization would be an example. And then, of course, the final being unencapsulated SRM. So that was the context within which we assessed existing national laws and regulations in each of those jurisdictions. And our case study findings are perhaps not terribly surprising, that there's high-level policy debate in all three jurisdictions, but little academic and policy debate on the suitability or adaptability of national laws and regulations to govern either research or deployment. And this is because detailed regulatory assessment is necessarily hypothetical and at times speculative, given the state of technology. Unsurprisingly, no bespoke geoengineering regulation, but we did concur with the Royal Society report's assumption, at least with respect to these three national jurisdictions, that there is the potential for the adaptation of existing climate environmental laws, planning controls, and regulation of scientific research, but with an acknowledgement of the regulatory diversity amongst just these three jurisdictions that we looked at. Imagine mapping that on to the nearly 200 states in the world. And one significant difference amongst the three is the constitutional acknowledgement and protection of scientific research in the German Basic Law, for example. We don't have that constitutional overlay in the UK, obviously. And as I'll go on to point out in a moment, within the domestic framework and mirrored on the international level, it is unlikely that a single body, authority or agency would have a full mandate, that collaboration between fora would be necessary. I think it's important to acknowledge from the presentations we've heard about SPICE that the legal framework was one of the steps, complying with any legal requirements was one of the steps that was undertaken with the testbed. And even though it wasn't cancelled because of public opposition, a point to make that we always need to bear in mind is that even if we have detailed rules, full compliance with what a state may require with respect to authorizations, permissions, etc., may not be sufficient in terms of compliance, in terms of a social license to operate. So we need to keep the legal license to operate and the social license to operate clear in our minds. Okay, there's also obviously cross-fertilization between the national and the international framework. So when I said our methodology was to look at these two, we can't say that national jurisdictions and international law operate in splendid isolation. And in fact, it's striking that in the UK policy discussion, there has been an emphasis on the need to have international governance. So this isn't a task merely for the individual state. This is an issue for international governance. That may be a way of taking some of the heat out of the debate, saying we're not going to regulate it unilaterally, a multilateral approach is necessary. But I also think it's an explicit acknowledgement that whichever technique we're talking about, encapsulated or unencapsulated, there needs to be some degree of oversight, some degree of ensuring that you know what State A, State B, State C are doing in terms of detection and, as we heard it earlier, detection and attribution, for example. Who's doing what and what effects is it having? So that degree of international oversight. And there's a scope clearly for international norms to percolate down in terms of top-down and bottom-up governance initiatives. I'll come back to that point. So on the international level, we identified three possible models for governance. One is the adaptation of existing instruments. You look at existing tools and see if they're fit for purpose. The second is to identify regulatory gaps and see whether those can or should or need to be filled by a creation of a new bespoke instrument. And the third is non-binding general principles of conduct or guidelines that could be promulgated by an international institution, by a state, or concerned individuals, scientific organization, etc. Now these, of course, are not mutually exclusive. They can work in dynamic interaction, as I'll come on to discuss in a moment. But what's missing from this model? There is an obvious gap, and it's one we're all aware of, that there's no existing geoengineering treaty, and that in fact there's little direct international regulation of any geoengineering activity, depending of course on how we frame it. Certain forestry projects of course are regulated under the climate change regime. Carbon capture and storage has been addressed globally and regionally in the dumping conventions. And of course oceanine fertilization, because of concerns about ocean acidification and concerns about the state of the marine environment, has been addressed under the London Convention and Protocol. But these are not generic approaches, these are technique specific. There is an indirect constraint on geoengineering in that we do have a treaty that prohibits the hostile use of weather modification and environmental modification. But of course there the intent is hostile manipulation to cause harm, so query whether this would be suitable for many of the activities we're talking about. And of course this is a background prohibition. What it doesn't provide us with is a positive regulatory framework for assessment framework of research, etc., etc. So it's a negative rather than a positive. But it's not a totally blank slate either, even in the areas of regulatory gap that I'll come on to in a moment. That is to say that there are certain general legal principles that apply, and one that immediately is relevant here is the no harm principle, that states have the obligation with respect to actors under their jurisdiction and control, whether it's an individual scientist, a company, an aircraft, or a ship, to ensure that they do not engage in activities that cause harm, significant harm, across the boundary to another state or to areas beyond national jurisdiction, which means the atmosphere or the oceans. Now, that is a general principle binding on all states. It's an obligation of due diligence. But again, what it doesn't give us is a scientific assessment framework for research. It doesn't give us the concrete rules and guidelines that we might be looking for in terms of a governance framework. It doesn't provide for public participation in environmental decision making. It simply says the state has this obligation, and of course, it kicks in when harm has already been caused. So it's more of a retrospective than a prospective limit on state control. Precaution, of course, the precautionary principle is another general principle that can apply, but its existence as a binding rule of general law is somewhat doubtful. Its main operation is when embedded in, yes, specific regulation and treaty instruments. So, in terms of the three models, the first thing we did with the international treaties was to come up with a set of assessment criteria. And I know there's quite a lot there on the slide. I'm not going to go through all of them. But if you will, with each of these criteria, we were assessing existing instruments, whether it's the Convention on Biodiversity or the London Convention and Protocol, and asking how many, if any of these instruments, actually tick all of these boxes. Do we have a big green blob in the right-hand corner, to use the Royal Society blob diagram analogy? And the answer is no. No single instrument has a sufficiently broad mandate, is sufficiently robust in terms of implementation and enforcement, or indeed has parties with the political will to develop a substantial framework. The closest we have to a generic vehicle for regulation is the Biodiversity Convention, but it falls down on precision of the obligations. Its fundamental concern is the conservation of biodiversity, so whatever action is taken needs to fit in with that broad mandate. And some of the slides we've seen today, of course, indicate that impacts on biological diversity, those biologically diverse rich regions through the equatorial regions, will be a significant factor and will be part of the CBD's concern. But it's not a holistic one-stop shop for geoengineering. So applying these assessment criteria, no single institution emerges that ticks all of these boxes. So that is the no one-size-fits-all approach. And it's also important, as we're going through the various international instruments, to bear in mind what I've called here legal instrumentalism. Are we using legal tools and techniques to keep our options open, and to encourage sufficient geoengineering research? So it depends. I think that would be, Rose, your square up in the upper left-hand corner, the planet engineers. Or is the role of law to limit the potential risks, the problem of, alleged problem of, or perceived problem of too much research, the risks that go from that, even to impose silence, which might impose a prohibition or a moratorium? Do we have a one-size-fits-all approach? Do we try and concretize the Oxford principles that can apply across the board, or is detailed case-by-case regulation, such as the London Convention Protocol for Ocean Iron Fertilization, a more effective method? And should the rules be binding or non-binding? That is to say, go down the treaty route of binding rules, but ensure a bottom-up generation of guidelines. What we've seen in practice so far is a step-by-step approach, to start with non-binding through a resolution of the parties to a treaty, followed by treaty amendment with future-proofing, and that's the London Convention and Protocol approach. I'm going to skip over the next couple of slides and come on to option 2, because I pick up on some of those themes at the end. Option 2 is creating new regulation. Should we negotiate an instrument, binding or non-binding, to fit the geoengineering governance gap? Well, the first thing to say is there's little appetite for lawmaking on this scale. And there's, of course, the problem of participation, effectiveness, and enforcement, and overlap with existing treaties and institutions. We don't have, of course, a blank slate. There are a lot of treaties already out there that have carved out their niches, sometimes very substantial niches of expertise and regulation. So whatever is going to fit that governance gap needs to map on to those existing instruments. But there is a gap. And the gap is clear. It's with respect to solar radiation management and regulation of activities in the atmosphere. It's a governance gap in the sense of the absence of detailed legal rules and an institution with competence to regulate with respect to the atmosphere. So at the moment, we have some regional pollution treaties, we have an ozone convention, and we have national airspace, and that's it. And there are discussions about generating a convention to regulate the atmosphere that we have for the oceans. If we were to see such an instrument emerge, one of the cardinal principles would be protection of the atmosphere and even perhaps acknowledgement of it as the common concern of humankind. The final point on bespoke regulation is that were a new instrument to emerge, there would be an overlap with the existing treaties that would need to be addressed and a degree of harmonization, whether it's through the treaty secretariats or other informal mechanisms of control. And the third governance option I mentioned is voluntary guidelines. And again, this came out of the Royal Society report in 2009. And of course, it could sit very well against both existing instruments, but also any bespoke new instrument that might emerge. And of course, it could sit also against, if one were desired, a moratorium on deployment. It wouldn't sit so well with a moratorium on research. There would be a fundamental inconsistency there. But certainly one could see the development of such guidelines amplifying and indeed pushing, perhaps leading to hard law within some of the instruments that we've looked at. So the final remarks, these aren't recommendations so much as final remarks. Currently, we have no existing international instrument which provides a blanket prohibition on all geoengineering unless it's for a military or hostile purpose, and that would be as customary law under NMOD. There are questions of the scope and the competence of existing institutions to take on this role of articulating general rules for geoengineering. So I've put Biodiversity Convention, question mark. There are treaty and customary international law constraints, even in the absence, however, of a bespoke geoengineering instrument. And these are the no harm principle I referred to. Article 192 is from the Law of the Sea Convention. There's a general obligation at customary law and in treaty law to protect and preserve the marine environment. So if harm is caused to the marine environment, that's a breach of customary and treaty law. In terms of the methods that we looked at, carbon dioxide removal is relatively well regulated or capable of being so under existing local, national, regional, and international law, but there are gaps clearly for SRM, and the customary rules are an inadequate substitute for detailed regulation, structures for decision-making, public participation, assessment of harm, detection, attribution, etc. And there is, of course, a need, because of that fragmented picture that I've referred to, of at least having some method of cooperation or coordination amongst the methods through looking at cumulative direct and indirect impacts, and that's both positive and negative, and of course avoiding the dangers of regulatory fragmentation. There is a strong consensus under those international instruments which have considered geoengineering in the London Convention and the CBD on the need for a governance framework before deployment, and in the short term, governance frameworks for research. But whatever framework emerges, including the assessment framework that we now have under the London Convention and Protocol, that there needs to be a degree of regulatory flexibility in terms of responding to changes in scientific knowledge and completing that feedback loop as detection and attribution is fed into that process. To use the language of the London Convention and Protocol, flexibility and future-proofing would be key. Thank you.